Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
Why don't we go ahead and move to confidentiality in Article 30? So I guess the one comment I will make is that a lot of the arbitral institutions in the States don't always make confidentiality responsibilities of their tribunals and parties very clear. So I appreciate that Article 30 has tried to make those obligations as clear as possible, and also has expanded those responsibilities to not just the parties, but others who are involved in arbitration. Can you tell us a little bit about the reason for that update?
Yeah, thank you. I mean, confidentiality is one of these, if you speak with users, the ultimate users, often confidentiality is named as one of the perceived advantages of arbitration. And if you then look at the applicable rules, there's not always a basis for that. And then you need to look at the applicable law, and sometimes there is support for confidentiality there, but not always. Now, there are cases, in particular state cases, where there is actually a need or a desire for transparency. So I'm not saying that there should always be confidentiality, but it is extremely important that if users choose arbitration for confidentiality, that you have a proper basis for confidentiality. And if you have that, it is important that you provide for this in a comprehensive way. And that's why we've expanded Article 30 to ensure that it's not just the parties in the strict sense, but also the experts, fact witnesses, court reporters, who you may not be able to bind directly, but where you say to the parties who bring a case, it is upon you to ensure that they too are going to be covered by a similar confidentiality requirement. You can opt out of Article 30 if you wish, but it is clear with the LCIA rules that the default position is that Article 30 imposes confidentiality on the stakeholders in the process. And from what we hear, that is what users want in our cases. That is not to say that that is true for each and every case. And I mentioned state cases. I've been contacted a while ago in relation to possible reference in a bilateral investment treaty to the LCIA rules, where the question was, is there something we need to do? And then I did flag Article 30 and say, well, be mindful, because that may not be what you want in that case. So keep in mind that the default is Article 30. And if you wish to do something different, then you've got to do that yourself.
Okay, one of the things that I gathered from talking to Kwadwo and others is this idea of getting witnesses, experts, service providers alike to sign on to the confidentiality requirements is something that's not normal, at least across the pond, which it is here, because particularly in court. I mean, we have protective orders, and generally when the judge signs a protective order, that protective order will say that anybody who you provide documents to will also have to sign on to the requirements of this protective order. So did I get this wrong, that wrong, or is this something that you're not used to on that side?
Well, there is certainly support for this type of approach also outside of the US. The International Law Association did a report on confidentiality a couple of years ago and came up with a draft model clause in relation to confidentiality. And this is actually one of the techniques that was embedded in that draft clause. So it's hard to get a more universal forum than the International Law Association. I don't think it's embraced or used as much in every jurisdiction as it is in the States, but I don't think it's unknown. I mean, there are some countries where apparently this is not common and may not even work, but you can amend. This is the default situation now, to ensure that we don't have a provision in Article 13.1, which is effectively undermined by a provision or by the absence of a provision that deals with the related parties who are not themselves bound by the arbitration agreement.
All right, so let's talk about 2024A compliance. So it seems from the text that the LCIA is making it clear that it can refuse to engage in any activities that might subject it to any regulatory inquiries, and also that parties are required to comply with applicable regulations. Again, can you talk a little bit about that update and the reasons for that update?
With pleasure. I mean, these are provisions which you may not yet have seen in other rules, although if you look at the practice of other institutions, this is definitely not novel. It makes more transparent what happens in cases, and I don't want to suggest that this is something that we anticipate will be used frequently, but it is important that we are transparent about, let's say, clashing interests, where you have a party who would like to bring a case, but if there is what is referred to here as a prohibited activity, the hands of the LCA, the hands of the arbitrators are to some extent bound, and we cannot work miracles. We have to enforce the law. And people often refer to this in a very abstract way, but I have myself not seen other institutional rules which are so explicit about what that means. Again, we should see this in perspective, because we do not anticipate that this is going to affect many, if any, cases, but it is helpful to have an explicit provision that allows us to say to parties, we're struggling here because on the one hand, there's a requirement for us to administer a case, but at the same time, we all need to abide by the law.
So I know one of the main concerns, and I read an article that you did in 2017 with a couple of other arbitral institutions where you talked about sanctions and the EU sanctions possibly prohibiting you from working with certain sanctioned parties. And I think you were talking about Russia in that article. Is that one of the main concerns here? Is kind of my first question. And also, it seemed like from that article you were saying that, look, we're not telling you that if you're a sanctioned party you can't come to us, but we have to have certain rules and requirements in place where we're doing our due diligence and considering what the law requires. So that's kind of my second question is, and I guess that's really just one question.
It's a bit of a mix, isn't it?
Yeah.
The first question builds up to the second.
Yeah, right.
Yeah, I mean, sanctioned situations are definitely something that would be captured by this provision. And interestingly, despite the large number of Russian cases that we handle, very few cases ultimately are affected by sanctions. But it may be that in order for us to process these cases, if we need to process funds, it may be necessary to obtain licenses. And of course, what you want to avoid as an institution is that a party says to you, well, you must do this or that. And we say, well, yeah, but we also must go to the authorities to obtain a license. And other institutions are in exactly the same situation. And I've seen other institutions using fairly draconian wording to say, well, we're happy to register this case, but we're not sure that we can transfer you any monies. And we felt that it was quite important in the rules to codify that where there are clashing legal obligations, as an institution, we need to ensure that the institution and the arbitrators act in accordance with the law. In practice, with sanctions, in most cases, that can be resolved by seeking licenses. And then we will do that with the parties and also on the basis of information that we seek from the parties and that we expect the parties to provide to us when they bring their case.
So a little bit about kind of what you're doing back office in order to, I guess, what we call a conflict check, or things that we do from a regulatory perspective to make sure that we are covered from a legal perspective. I understand that you also have some things set up where you're looking at parties, and you talk a little bit about that, about what you're doing to vet parties.
Absolutely. Many institutions do some due diligence or vetting at the outset. There's a bit of a range, if you will. I mean, some institutions are more meticulous than others. Some feel, as a matter of principle, that this is not something that they should engage in. At the LCA, we definitely check, and you always need to look at which laws do you need to verify. The LCA is based in London, and that is currently means that EU regulation is our first port of call. From 1st of January, we will primarily be looking at UK legislation, but there may be connections with the United States, in which case OFAC rules and regulations are relevant. It is really important in the context of sanctions to stress, and that's something that we did in this article in 2017 that you referred to. It is something that as stakeholders in the arbitration process, we need to do together. It is the institution, the arbitrators, the parties, and their representatives. And their interests are aligned. Obviously, one party's interest may, at some point in time, clash with the interests of one of the other parties. But in order to make this process work, it is important that we realize we're in the same boat. And as an institution, we need to rely on the information that is provided to us by the parties and their representatives. We can only do so much. We do not know precisely what the factual scenario is that has caused a claim to be brought. We can see who the named entities are, and those are the names that we search for in the various searching tools. But we also write to the parties to say, if there's something that we should know, it is upon you to tell us, because we don't have a crystal ball that we can look in. We need the information to be coming from the parties in order for us to do our work. But then we work with the parties to obtain the licenses, etc., to ensure progress in the case once we administer it.
Okay, so Jackie, the next session we want to talk about is Article 30A, which is on data protection, and this is a completely new section. And of course, data protection is on the minds of everybody, privacy as well as cybersecurity. And in this instance, it seems like you put the onus on the arbitration panel to adopt any necessary information security measures or any privacy related measures. So what can parties expect as a result of 30A?
Good question. First of all, the purpose of 30A is to ensure or to reassure the parties that the LCIA acts in accordance with the applicable data protection legislation, and we're updating our privacy notice, etc. But it is also a reminder to the stakeholders in the case at hand, which is the arbitrators, but also the parties, that they need to do what needs to be done. What is a bit tricky is that we're talking about data protection broadly, because we cannot say, for instance, that parties need to abide by the GDPR rules. That may be relevant in some cases, but we administer cases that hail from all over the world. So it depends on the applicable rules and legislation, which data protection rules are going to be relevant and what exactly they provide. But what we have sought to do here is to make it clear that this is something that cannot be shoved under the carpet. It is not necessarily something that everybody is going to be super keen to address. But we were speaking earlier about enforcement. What we definitely want to avoid is that a tribunal spends time, parties, and tribunal spends energy, parties spend money on a case where ultimately there are issues, fundamental issues, that jeopardize the enforceability of the award because people have simply overlooked this issue of data protection. There's a lot of work ongoing in the context of ICA, IBA. They have a working group. So there is now increasingly know-how about what arbitrators should do, what parties should do, and they should basically have a conversation about this issue. And that's what we're doing here. We're reminding everybody, don't ignore this because it's going to come and haunt you. That's not to suggest that there's a one-size-fits-all template that you can simply roll out and apply, but have a conversation about it.
So, and touching on the point about the template, so a couple of the arbitration institutions that I work with, they provide arbitrators best practices for cyber and also for privacy. Is that something that you're giving the arbitrators that they might be able to incorporate into their orders and that type of thing?
We don't currently have explicit templates in that sense. We are going to be doing a podcast on data protection. We've been very involved in the ICA-IBA task force, and I think we'll be looking mainly at the product of that task force to potentially be used by our users, and maybe at some point we'll provide further more granular guidance. But at this stage, there's not something we can direct parties or arbitrators to.
All right, one more question and back to you, Kwadwo. I think if I heard you correctly in your podcast that I listened to, that you're in the process of building a secure case management system. Did I get that right?
Well, I'm happy to say we have a secure case management system as we speak. But we are updating that. And what we contemplated is potentially to provide an external platform, which some other institutions have and others don't. What we decided is that we would first invest in bolstering the internal system, which will not preclude us from subsequently rolling out an external system, but we are definitely making changes to the internal system. So that's probably what you picked up in the podcast.
And I was probably talking about an external system. So are there any plans? Is that in the works, or you're gonna just
not currently?
Okay.
No, not currently. We are currently focusing on the internal, the updates to the internal system.
Okay. Data protection. I'm done with data protection. Kwadwo, anything for you?
So I would just simply comment that this really ties back to what we were saying earlier about Article 9 and Article 4 and the encouragement and facilitation of digital communication. I think it's really important and laudable that in addressing data protection in the way that you've done, you're giving parties additional confidence in using those means to conduct and support their arbitrations. So I'd like to move on now to look at tribunal secretaries. And Jackie, I think the last time we caught up face to face, we were in Nairobi for the part of the LCIA Tribunal Secretaries Roadshow. And there was some very fascinating discussion and debate on the role of tribunal secretaries. And we note now that what was previously the guidance and best practice put forward by LCIA is now set out in the new Article 14A. So, could you give us a few of your thoughts and observations about these changes?
Thanks. Yes, that was a fun and interesting session we did. These provisions on the use of tribunal secretaries are not intended to change the guidance that was contained previously in these guidance notes. When the committee of the court at that time proposed these provisions, it was already the intention, if and when the rules were going to be updated, to include the wording in the rules update. So that has been the plan from the outset, and that's now been done without any changes. I mean, there have been one or two tiny tweaks to the terminology to make it more consistent. But the real thinking about these provisions has been done a few years ago. And basically, what Article 14A does is to codify what we think is best practice, in the sense that it is not for the LCA to say in an individual case whether there should be or there should not be a tribunal secretary, but we want the rules to provide an adequate framework if and when arbitrators and parties choose to deploy a tribunal secretary. And that means that there needs to be agreement on who this person is, what their tasks are, what the hourly rate is that's going to be applied by the tribunal secretary, and there needs to be agreement, or there needs to be a declaration of independence and impartiality signed by the tribunal secretary. So those key issues need to be agreed beforehand, before anyone can start acting as a tribunal secretary.
And in this regard, we saw in the English case of P&Q how the English court certainly firmly and robustly endorsed the LCIA court's decision-making process and how it had dealt with arbitrator challenges and the issues around tribunal secretaries there. Did that play a role in prompting LCIA to set these out as actual rules rather than guidance?
Not directly. P versus Q was an LCA case, so it happened to coincide with the thinking that this was an area of practice where users would benefit from further guidance, and at the time it was not deemed practical to change the rules simply to, or only to make this amendment. At that time it had not been decided yet whether there would be an immediate change to the rules, which is why the decision was made initially to contain it in these guidance notes.
Excellent. So now that they are in rules rather than guidance notes, does that expand the options that a party might have if they suspect that a tribunal secretary is perhaps exceeding its terms of reference or breaching the rules and the guidance in some way? Now they're rules, do you feel they've got more bite?
Formally, perhaps, because there is now, you could potentially argue over the status of these guidance notes, but because the content is not really any different, and I'm happy to say we've not really had issues about the scope or the breadth of these guidance notes. I don't think that is going to be an issue, or that we anticipate further challenges. It's helped to grow good practice, because sometimes arbitrators may just overlook these provisions, and I would hope that by having the provisions in the rules, people are going to be even more aware of the need to address these issues.
Thank you very much, Jackie. Well, I'd now like to move on to our final subject, and that is the advance payment for costs, the treatment of costs that parties have paid, and tribunal fee rates. So we note now the change in Article 24.2, and that the LCIA court will now be holding fees on trust for the parties. What's the thinking behind this change?
It is an administrative change. So going forward, there will be a simple debtor-creditor relationship governing the administration of the funds that are held in arbitration matters. It was just an opportunity to ensure that the practice matches the applicable guidance, both from a regulatory perspective and from a practical perspective. We will be operating separate bank accounts for the new cases to ensure that there's no commingling, if you will, of cases where the funds are held in trust, and for the new cases where the funds will be held on a debtor-creditor basis. And you already identified in your question this issue of the hourly rate. In a way, it's a bit of a spring clean, and that also ties into my comment earlier about updating our internal administration system. There is going to be an increased maximum hourly rate, which will only apply to new cases. So in existing cases conducted under 2014 rules, there's not going to be the ability to benefit as arbitrator from the new rates, which will only be applicable in relation to the 2020 rules cases. This is very much a reaction to user demand, where we were in a few cases confronted with parties and arbitrators united in their request to be somewhat more flexible in complex cases and accommodate higher rates. As an institution, you're always anxious to serve the best interest of the parties, which you would think is to limit the hourly rates that arbitrators are entitled to. But we recognize that there are cases where, either because of the complexity and or, for instance, the duration of the case, if arbitrators need to remain conflict-free and need to dedicate time to a case over a very long period of time, and in particular where they are then in agreement with the ultimate users that that is an hourly rate that they are supportive of, it's not necessarily helpful for the institution to say, well, our maximum is 450 and we cannot go above that. There's always an escape provision in the rules that in exceptional circumstances we could go above the 450, but that is not really intended to be used other than in exceptional circumstances. But we now have the instrument of a maximum hourly rate of 500, which will be very much a fact-based analysis by the court in each and every case, whether there will be a higher rate. It's not intended to be an automatic £50 increase in each and every case, but a bit more room to maneuver, in particular for complex cases.
That is good to hear, and I think that chimes with a general theme in a lot of your answers. This is really about flexibility and the LCIA responding to the needs and desires of the arbitrating parties themselves. Unless, Chucky, you have anything else on fees, or perhaps any observations of whether, by American standards, that's a reasonable rate for an arbitrator or not.
You know, it's kind of cheap, but look, it's okay. I'm sitting here in my head as you were talking, trying to do the conversion. You know, but look, it's more than healthy, and you know, some of these rates have I probably shouldn't say this, but have gotten way too high. But my last question, I think, is not about the rules, but also a general question about how people get involved with the court. Like what is the process for people getting on the court? And, you know, if you're an arbitrator sitting in the States like me, how do we get involved?
Well, it's great to involve as many people as possible. We have Users Council, which are the most immediate tool. We have a Users Council in North America. And normally we organize in-person events, and these days we organize virtual events, and we will actually be organizing virtual events also in the different jurisdictions where we will involve people. We're potentially going to do something similar to what we did with the Tribunal Secretary Roadshow, where we involved people to be part of a role play where we demonstrated some in a slightly lighter and more practical fashion. So that's something we are contemplating doing in relation to the rules. But to go back to your question, Chuck, that is through these user councils. We had been hoping to be in North America next month because we always do events around the IBA. That's not going to be happening in person, but you know, there will be other activities that the LCA is going to be focusing on in North America specifically. I'm also very excited about the Halliburton versus Chubb case, where we expect a judgment in the near future, which a case where the LCA has intervened the issue of arbitrator independence and impartiality and disclosure, something that's close to all our hearts, and also very much something I imagine will be the subject of further discussion with our American users. So yeah, check the website, see what events we're doing, and any initiatives or any ideas that you have, what we can do to be more visible in the US are very welcome. And that includes, of course, the wonderful opportunity you gave me today to talk a bit about the new rules.
Thank you. That's helpful.
So, Jackie, to wrap up, first off, thank you so much for taking the time to go through these changes with such detail and such clarity. We really appreciate it, and I'm absolutely sure that our listeners will too. It's clear that these changes and updates will further strengthen the effectiveness of the LCIA rules and further promote arbitration as an efficient and cost-effective process for parties to resolve their disputes. It's clear that a massive amount of work and thought and consultation and taking account of the interests of the various stakeholders has gone into this process. So thank you very much indeed. It's great that these new rules have come into force, and we really appreciate you taking the time to take us through them.
Well, thank you for your perceptive questions and your time, and I hope everybody will indeed enjoy this podcast.
Thank you so much.
Thank you.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo, Sarkodie or Charles Harris, you can find them at the Mayer Brown website, mayerbrown.com. Also, to learn more about other Mayer Brown audio programs, please visit mayerbrown.com/podcast. Thank you for listening.